The Points TV so any episode 4 Yamama Kwaba Edeba ye channel ye so open number 1 channel ebema all the political issues eko so ewo man Ghana mu ade a ene na make am for the Points TV ede amao. Mess also be subscribe to your YouTube channel na Facebook like video ede amame. Share ma foforo nya bi hwe for comment so bra ewo comment section wo. Ensem bebre eko so ewo man Ghana ye politics mu. Na NDC for no ede omo de namfa, MPP for ede namfa, CPP ni other political parties ni nyina omo de namfa. Ebusua ensem bia ba beto dwa editie na dihwe ensoso. Yenko na yenko hwe video ya etwagui emra.
Ordinary people, they are not lawyers. No. That 3 must hold.
Right.
Because it's a majority. And then thereafter, there is no appeal.
The matter is closed.
The matter is closed. Well, I mean, my brother, if it were you, we would like to appear before such a court. It's ridiculous.
Yes.
I don't blame anybody. It's there in our law.
So therefore...
Let me just finish this. Why even is it that Ghanaians have watched this being their law for so long, and some people who today are criticizing the system said nothing. They did not speak about this. When I was mounting the IEA Constitutional Review series,
right,
I wrote on all these things. I said, oh, there is my paper already. It is published in my contribution to the University of Ghana alumni lecture on the Jubilee, which I gave,
right,
at the Jubilee time, which I gave in the Great Hall in Legon. 10 years ago, I had written on this, and so on and so forth. Why do we allow such things to happen? And then we cry foul when it appears as if it means therefore that once the president decides you should go, you're on your way out. You know, I don't know why very often we don't analytically record historical events. There was a fine judge in the Supreme Court, Justice Amwasechi. The right to demonstrate in some of the early Supreme Court cases, he expounded the law.
Right.
And for that matter, enhanced the human rights of Ghanaians. But some people didn't like him at that time. At one time, there was an attempt to get him of him in this way. And then the good old, well-established lawyer and judge, when they were in the process of going to do empanelment and so on and so forth, he read between the lines and retired from the judiciary.
But Prof, I'm curious to know, I mean, are you happy with how the process has been handled so far, from when the petition was presented to the CJ even requesting the president to give her a copy of the petition, and then the subsequent exposure in the media about the content of the petition, even the CJ's response to the petition?
I have not followed that aspect well. Because I have not read the fullness of the report. I've seen what we call excerpts in the media. That also goes to factual issues before the court. I mean, it's not a judicial panel. Therefore, I personally would not like to go there because it can be said that it is prejudicial to the matter before that tribunal of competent jurisdiction. What I am very much keen upon is exactly the issue that I've discussed with you. And it must be resolved as a preliminary issue. Because if you were to put me in such a trial, I wouldn't go. And I wouldn't plead. I wouldn't say anything. You can do whatever you like. Because I would like the world to hear. And I bow out according to what is being heard. Putting a person in a room, coming out thereafter to say what occurred there. When in this country we have so much controversy over matters that even all of us are seeing and hearing. You will be surprised at all the interpretation.
You were saying that if you were in the shoes of Torkono, you would not appear before this committee.
I say, if it is going to be secret trial, I won't appear. You can do whatever you want to do.
because you don't trust the process?
No, it's not a matter. You see, I wouldn't want to single out any particular event.
Okay.
But as a matter of general principle, I am telling you, no Ghanaian would like to go through that kind of process. Watch him, them. I mean, it is a very, very important principle, and it's a human rights issue. And that's why I say that human right of the person who is the victim and accused in this case might be seriously examined. Give her that fair and open trial. And then we can all see. I'm telling you honestly, if a disciplinary action is given against a messenger in the judiciary, you know, he or she will be entitled to take the matter to the High Court when a decision is held against that person. And the Constitution says the person is also entitled to appeal to the Court of Appeal. And then you can take it to the Supreme Court. And furthermore, to the review committee of the Supreme Court.
Right.
But in this particular case, the person who is being tried in secret cannot even appeal. So let the world see it once and for all. It is a very, very important jurisprudential and human rights issue. Nobody wants a star chamber court. Nobody wants secret trial. Even in our traditional system, which is guaranteed by this constitution, our traditional law, customary law, and so on. That customary law, whether the case is a FISEM, that is a small family case,
right,
or it is Oman SEM, that is a proper national or village or town matter, the trial must be held in public. And on certain days, specifically set, and people can come and listen. Some people go to the court just to pass time. Do you know that? To go and hear cases. A person is entitled to hear cases in court.
In this case, it's even unclear whether the committee has started work. It's unclear whether the suspended CJ has appeared before them. But it's not too late to make changes.
I think it shouldn't be too late. And whatever has been done up to this stage, the Supreme Court should be able to go into this matter and declare whatever has happened so far null and void, and then start open trial. Because a Ghanaian's human rights are at stake. And it's very, very important. And that is why, look, there are many people who, if this is how a Chief Justice can be removed, will tell you, I'm not interested in the post.
In the post?
Oh, no.
Prof, indulge me.
It will happen.
Indulge me. Let's spend some time on this matter so that the understanding is clear.
If this is how a judge can be, of the Supreme Court can be cocooned into some room, 5 people, nobody can see some, nobody can hear some, and then after somebody will come and tell you the verdict, there are many people I respect strongly in the bar, at the bar, and at the judiciary who will say no.
This is a very important point.
It's an important point. We will be destroying the judiciary if you go this pathway. And I will come and be a Chief Justice. What for? I say 5 people chosen by 1 man. I'm not talking about even the person who chose. 1 person chooses 5 people of his choice, and then they can come out with any judgment which is done. The process takes place in darkness. I mean, in the closed room. Oh, no. There are many people who want to be judges.
And so you say that the court must declare whatever has happened null and void.
I say, I don't know even. But it is possible. I'm not saying what must be done. I'm not clothed with that power or authority.
You are suggesting that the court
But it is possible that the Supreme Court, having by the full bench, heard this matter on the purposive factor consistent with the basic formulation which precedes the judiciary, that justice belongs to the people and it is administered in their name and on their behalf. If the thing is mine and you administer it on my behalf, I should be able to come and see some.
But how would this work when whatever is happening is a constitutional, steps enshrined in the 1992 Constitution, where the president is only a conveyor belt in this matter, and is asking the process to flow? The court has no role whatsoever. So, is it a tax, for example, you are prepared to take in the court?
The power
in terms of uplifting the human rights of the individual,
sure.
In terms of opening the process up to ensure fairness and transparency.
It can be done. That is why the Supreme Court is there, to interpret the Constitution. Because I've given you parts of the Constitution which say otherwise. I've given you the jurisprudential history of secret courts, which we don't want. In the United States, and this is a law that everybody who's been to law school knows, Marbury against Madison, a fundamental issue which changed the face of the law and gave the judiciary the power to even quash laws made by Congress in Parliament. It was not specifically provided for in the Constitution. But the judiciary and its functions, which had been given it, the court, led by Chief Justice Marshall, came to the conclusion that, and the logical conclusion, that if we are going to go by the rule of law as so provided by our Constitution, then the law must take precedence over everything. And everybody, including the legislature in America, the president in America, he can declare what you have done ultra vires, beyond law, and for that matter, make it null and void. This is the purposive interpretation of a Supreme Court. And that is very, very important, because it tells you, marry all the principles. Don't just look at one provision and then say, hey, I've got something to run away with. That is, it must be done in secret. How do you reconcile it with the basic principles underlined in the Constitution? It is something that the Supreme Court must look at.
So, under the circumstances, under the current circumstances, you say that if these steps are not taken, if a person, under the circumstances, if these steps are not taken, a person appear before a committee whose hearing is shrouded in secrecy, then you're already gone. Well, more especially when the person who is facilitating this is responsible for selecting who should hear your case.
It is serious. And, there are so many political angles which I wouldn't want to tread into. I want to restrict myself to the obvious. Let everybody see clearly that, as for this provision, that one man can choose 5 people, and then they will go and sit in a room alone with the so-called accused and come out with their decision on the person. It's not fair.
But somebody must bring the Supreme Court, somebody must bring this to the attention of the court. Is this something that you're prepared to do?
I don't see why, in fact, maybe nobody has taken the matter to court still. Some serious Ghanaian must take this to the Supreme Court. And it is an interpretation that must be made by that court. And let them all, in their conscience, examine whether, if it were me, would I like myself to be subjected to this? Because, if you don't take care, a very dangerous precedent will be set. And I tell you, it will be
time bomb on a time bomb. As far as this matter is concerned,
time bomb is too strong an expression. But
this is an arm of government, supposed to be independent, being removed by another arm, and there's no remedy whatsoever.
And that is why I asked for a constitutional reform. And this thing is in black and white in my recommendations. My article at the IEA, published some 15 years ago, titled Countervailing Authority, it is there. My alumni address at the University of Ghana, it is there. We must change these things.
I will come to the attempt to review the Constitution, but because we are in the queue, should be sufficient enough to establish a prima facie case against a sitting CJ, since Article 146 doesn't give us that clarity.
You see, there is a case going on. We may say the matter in that regard is sub judice. I wouldn't want, and something has been said, we have a prima facie case already. I wouldn't want to say anything that will prejudice that. I want to take myself out of the controversial areas.
But you say that it is too easy as in the present circumstances to remove
it is too easy. It is too
and
easy.
And some say the threshold what is constituting the case against her, the threshold is so low.
I wouldn't say what is constituting the case actually. The threshold is low because I don't know all the charges. So I don't want to comment on that. I don't know.
The matters that are already in the public domain, you probably following.
Those things are supposed to be allegations.
These are being trumpeted by very senior government officials. And they say that they are even telling us the response of the Chief Justice to the extent that the communication officer of the NDC says that even when the matter was brought before the Council of State, out of the 31 membership, 30 voted in favor for the Chief Justice.
My dear friend, the person who said all this, if it is true, the Council of State was not established to be brought into the public light like this. If the Council of State have decided upon a matter in a certain way, it is not for you to come and tell the public what the Council of State, who are advisors to the President, said to the President. I don't know how any public officer will go on this tangent. And it's unfortunate. You mean to say that person really, I have not heard it. But if it is really true, to protect the person who is the subject matter of the trial.
Right.
Some people say, it's such a high office and so on and so forth, that whatever happens should not be washing dirty linen in the public and so on and so forth. But first and foremost, the dirty linen has already been washed in the public.
Absolutely, by the fact that you've been accused of...
Exactly. All manner of things.
Right.
So, if it is for the benefit, that's why I'm talking about a purposive interpretation, which the Supreme Court has seriously taken account of, since this was actually first hammered by Professor Justice Dateba. It's a very, very important thing because it goes to the root of the matter. Right. It makes you understand why the provision is there at all, and for that matter, the application thereof. So, it may be said that it is there for the benefit of the Chief Justice on trial. I don't want to talk even about a particular person. Whoever is the Chief Justice on trial. But as I said, the matter is already in the public realm.
It is. Indeed, people are even referencing the exact issues against her.
Exactly.
And so, the secrecy aspect is already broken.
It's broken. If that is so, then the purposive interpretation to enable you, the beneficiary thereof, to now say, I don't want a secret trial. I don't know the position of the Chief Justice. I am talking in terms of jurisprudence and analysis. I don't know. But in that case, the Chief Justice, whoever the Chief Justice is, should be in the position now to say, I don't want a private trial. I don't want 5 people to go and put me in a room and come out and say I'm guilty of all counts. I want the people of Ghana to hear what I have done and whether I am guilty or not, though so pronounced.
So basically your suggestion is that it should be the prerogative of the person facing this 5-member committee, in this case, suspended Chief Justice Getty Torkono, to demand that the entire process is broadcast to the hearing of the Ghanaian people.
Yes. Because I'm saying, to whom does that provision benefit? It's for whose benefit? You cannot do something for nothing. You cannot, and the basic rule in the law code is that you cannot put something on nothing for it to stand. And the whole concept of purposive definition is to give it meaning, to give it purpose. So I say the first purpose is the purpose of the public good, which is provided in black and white in the Constitution. It belongs to the public. It belongs to Ghanaians. If that is so, we cannot take it away from them. And because that too is also part of the Constitution. So if you put the two together, they don't really rhyme. And for that matter, one must go. And for that matter, the one that must go is the secret trial provision. That's what I'm saying. If you come to the other leg, that is, it is a human right of the person on trial that the dirty lily should not be played in the public. Therefore, let it be done in secret. Then the person turns around and says, I don't want that right. I will prefer that whatever you are going to do it publicly, so that my church members may know whether I'm guilty or not. I don't want a secret trial. Furthermore, my good gentleman, the whole concept of trial in secret is a very serious matter.
Why?
Because it goes against the very foundation of justice.
Justice must be seen to be done.
Exactly. Justice must be done. Not only that, it must be seen. In fact, some people even add manifest. It must be manifestly be seen to be done. To be seen by who? That's a foundation of our legal system. The British, even though they don't have a constitution, so far as matters of open trial and trial by the ordinary courts of the land, so far as this principle is concerned, they reduce this in the Magna Carta. As for this matter, let us reduce it to writing, because it goes to the foundation of our society. We all know the history of this country. The public tribunals, their accusers, nor their adjudicators. We have decried it, and we say we don't want that kind of thing anymore. Maybe it's an unfortunate relic of the bad old times. And people must seriously re-examine it again. And that is why we can give a purposive interpretation and say it is not congruous with the provision that justice belongs to us. It belongs to us, and we all want to, if we may say colloquial English, see some.
Okay.
But
I'm trying to understand the wisdom behind the framers of the Constitution as far as, I mean, the provision 146+8 is concerned. I'm trying to understand perhaps what motivated them to have come to such a conclusion. And you say that sometimes it is to protect the office of that particular person. Even in matters relating to national security, after they say because of the sensitive nature of the matter is in question, the trial must be held in camera. So if the person in question...
Even a part of the trial must be held in camera. That is when they are going to discuss maybe some security documents. But as for the trial per se, a person must ordinarily be tried by the ordinary courts of the land. You remember the Chachu Chikata case?
Right.
He made a very important pronouncement on human rights. He said, I want to be tried by the ordinary courts of the land, not a special court.
I was for what to be one with the echo so a woman Ghana, your politics, emo. So what dream and answer for our comments, bra. I will comment section video she mess also be like it and so me share my for you be share na ve for comment in the bra I will comment section I was answer me kan the Punch TV makramo.